All right, Inez, that's the claim from the left, particularly the pro-abortion left, I think, feminists. They say it doesn't matter what public opinion says, it doesn't matter what pro-lifers think. Roe v. Wade cannot be reversed, cannot be overturned because it is settled law. Inez, is that true or false?
Of course, that's not true. The justices of the Supreme Court, their very first obligation is to uphold the Constitution. And if the Constitution was wrongfully interpreted, as I think there's a broad swath actually from right to several very well-known legal commentators on the left who say that Roe v. Wade was wrongly decided, wrongly stripped those powers from the states to determine for themselves what to do about the question of abortion, then absolutely it can be overturned. I think it's more likely that it just gets narrowed over time, like many other precedents. But there are, history abounds with examples of Supreme Court precedent that stayed in place even for years, for decades, and then was overturned.
Right, and I want to talk about some of those cases before we even get into the nitty-gritty of why Roe v. Wade has no constitutional basis. But I want to talk about this precedent being overturned by later cases. So Dred Scott versus Sanford, the Supreme Court ruled that black people in America were not citizens. That was precedent in our country. That was the law of the land for years and years, decades, in fact, decades upon decades, until it was overturned. It was overturned. And black people, obviously, under our Constitution, are citizens of the United States. Plessy versus Ferguson, Supreme Court ruled to uphold racial segregations. 60 years that was precedent. Over half a century that was precedent until it was overturned by Brown versus Board of Education. That one specifically, the Supreme Court overturned their own ruling. They reversed something that same court had said previously. If those two cases aren't, to use this word, ironically, I suppose, if those two cases aren't precedent for a ruling to be reversed, I don't know what is.
Yes, and actually this court actually technically overruled a long-term precedent, Korematsu, which was the case that allowed the federal government to actually intern the Japanese, that upheld that order from the federal government. And that was actually recently technically overturned, although it was considered a dead precedent long before that. And there are many other examples of this. And in fact, there's no actual legal basis for the idea that a precedent can't be overturned because it's, quote, long established. Now, there is the legal concept of stare decisis, which means that past precedent should be respected to the extent that it can be squared with an interpretation, a good interpretation of the Constitution. We don't want our law of the land to be swinging wildly depending on who's on the court. That being said, and this is one of actually the debates within the right among originalists, so the late Justice Scalia gave a little bit more deference to stare decisis than, say, a Justice Thomas would. Justice Thomas would say the very first thing that a Supreme Court justice should do is interpret the Constitution, and if that conflicts with past precedent, too bad. But even Scalia, who was much more deferential to stare decisis, thought that Roe v. Wade was a very bad decision that needed to be chipped away at and potentially overturned.
Want to see more videos like this? Click on the link below and subscribe to One America News on YouTube. And call your cable provider and kindly demand that One America News is added to your lineup. Call and subscribe today.